Post-employment, employer-employee relationship, Article 97, definitions, as used in this title. A person means an individual, partnership, association, corporation, business trust, legal representatives, or any organized group of persons. B, employer, includes any person acting directly or indirectly in the interest of an employer in relation to an employee and shall include the government and all its branches, subdivisions, and instrumentalities, all government owned or controlled corporations and institutions, as well as non-profit private institutions or organizations. C. Employee includes any individual employed by an employer. Article 173, definition of terms, as used in this title unless the context indicates otherwise. F. Employer means any person, natural or juridical, employing the services of the employee. G. Employee means any person compulsorily covered by the GSIS under Commonwealth Act numbered 186 as amended, including the members of the Armed Forces of the Philippines and any person employed as casual, emergency, temporary, substitute or contractual, or any person compulsorily covered by the SSS under Republic Act numbered 1161 as amended. H. Person means any individual, partnership, firm, association, trust, corporation, or legal representative thereof. Article 219, definitions. F. Employer includes any person acting in the interest of an employer, directly or indirectly. The term shall not include any labor organization or any of its officers or agents, except when acting as employer. G. Employee includes any person in the employ of an employer. The term shall not be limited to the employees of a particular employer unless the code so explicitly states. It shall include any individual whose work has ceased as a result of or in connection with any current labor dispute or because of any unfair labor practice if he has not obtained any other substantially equivalent and regular employment. The existence or absence of employer-employee relationship is a question of law and a question of fact, each in its defined sense. The existence of an employer-employee relationship is ultimately a question of fact as decided in SSS versus Court of Appeals and Ayalde, decided 2000. The conclusion is that an employer-employee relationship depends upon the facts of each case. In this sense, it is a question of fact. However, it being question of law means that it cannot be made subject of an agreement. Tabas et al. Versus California Manufacturing, decided 1989. Hence, the characterization of the law prevails over that in the contract. In this sense, the existence of an employer-employee relationship is a matter of law. 1. Tests to determine employer-employee relationship. The fourfold test. 1. Selection and engagement of the employee. 2. Payment of wages. 3. Power of dismissal. And 4. Employer's power to control the employee's conduct with respect to the means and methods by which the work is to be accomplished, as decided in Brotherhood, Labor Unity Movement of the Philippines et al. Versus Zamora, decided 1987. The most important element is the employer's control of the employee's conduct, not only as a result of the work to be done, but also as to the means and methods to accomplish it. Lirio versus Genovia, decided 2011. The control test calls merely for the existence of the right to control and not the actual exercise of the right. Zanoticius versus NLRC, decided 1995. Not every form of control will have the effect of establishing employer-employee relationship. The line should be drawn between 1. Rules that merely serve as guidelines towards the achievement of mutually desired results without dictating the means or methods to be employed in attaining it. These aim only to promote the result. In such case, no employer-employee relationship exists. 2. Rules that control or fix the methodology and bind or restrict the party hired to the use of such means. These address both the result and the means used to achieve it, and hence, employer-employee relationship exists. Insular Life Assurance Company Limited versus NLRC, decided 1989. Payment of wages. The court held that the fact that a worker was not reported as an employee to the SSS not a conclusive proof of the absence of employer-employee relationship, nor does the fact that respondent's name does not appear in the payrolls and pay envelope records submitted by petitioners negate the existence of employer-employee relationship. For a payroll to be utilized to disprove the employment of a person, it must contain a true and complete list of the employee. Southeast International Ratan versus Comin, decided 2014. Economic dependence test. Two-tiered approach. First tier, control test refer to the fourfold test. 2. Second tier, the underlying economic realities of the activity or relationship. Sevilla versus Court of Appeals, decided 1988. The economic realities prevailing within the activity or between the parties are examined, taking into consideration the totality of circumstances surrounding the true nature of the relationship between the parties. The benchmark of economic reality in analyzing possible employment relationships for purposes of applying the labor code ought to be the economic dependence of the worker on his employer. The standard of economic dependence is whether the worker is dependent on the alleged employer for his continued employment in that line of business. Orozco versus Court of Appeals, decided 2008. Evidence of employee status. No particular form of evidence is required to prove the existence of an employer-employee relationship. Any competent and relevant evidence to prove the relationship may be admitted. For if only documentary evidence would be required to show that relationship, no scheming employer would ever be brought before the bar of justice, as no employer would wish to come out with any trace of the illegality he has authored, considering that it should take much weightier proof to invalidate a written instrument. Tenazas et al. Versus R. Villegas Taxi Transport, decided 2014. Burden of proving employer-employee relationship. The onus probandi rests on the employer to prove that its dismissal was for a valid cause. However, before a case for illegal dismissal can prosper, an employer-employee relationship must first be established. It is incumbent upon the employee to prove the employer-employee relationship by substantial evidence. Javier versus Fly Ace Corporation, decided 2012. Piercing the corporate veil. In Sarona versus NLRC, decided 2012, the doctrine of piercing the corporate veil was applied. It involved the illegal dismissal of Sarona, a security guard who first worked at Scepter but was subsequently assigned to Royal, where he was illegally dismissed. In the computation of his separation pay, Sarona prayed that the corporate veil of Royal be pierced, as it was a mere continuation of Scepter. Hence, his separation pay should be computed from the time he was hired by Scepter. The Supreme Court explained that the corporate veil may be pierced when the corporation is just an alter ego of a person or of another corporation. Because the circumstances indicated that Scepter and Royal were one and the same office, same officers, same person exercising control and supervision over employees of both companies, and that Sarona's transfer to Royal was done in bad faith, the Supreme Court pierced the corporate veil and ruled in his favor. When applicable, the doctrine of piercing the corporate veil applies only in three basic areas, namely, A. Defeat of public convenience, as when the corporate fiction is used as a vehicle for the evasion of an existing obligation. B. Fraud cases, or when the corporate entity is used to justify a wrong, protect fraud, or defend a crime. Or C. Alter ego cases, where a corporation is merely a farce since it is a mere alter ego or business conduit of a person, or where the corporation is so organized and controlled and its affairs are so conducted as to make it merely an instrumentality, agency, conduit, or adjunct of another corporation. Maricalum Mining Corporation versus Florentino, decided 2018. This court has time and again disregarded separate juridical personalities under the doctrine of piercing the corporate veil. It has done so in cases where a separate legal entity is used to defeat public convenience, justify wrong, protect fraud, or defend crime, among other grounds. Ang Lee versus ang Samahang Manggagawa ng Superlamination, decided 2016. In Pamplona Plantation Corporation versus Sting Bill, decided 2005, the Supreme Court held that albeit Pamplona Plantation Company Incorporated and the Pamplona Plantation Leisure Corporation appear to be separate corporate entities, the fiction of law cannot be invoked to further an end subversive of justice. The principle requiring the piercing of the corporate veil mandates courts to see through the corporate mask may be removed and the corporate veil pierced when a corporation is the mere alter ego of another, where badges of fraud exist, where public convenience defeated, where a wrong is sought to be justified thereby, or where a separate corporate identity is used to evade financial obligations to employees or to third parties of separate legal entities should be set aside and the factual truth upheld. When that happens, the corporate character is not necessarily abrogated. It continues for other legitimate objectives. However, it may be pierced in any of the instances cited in order to promote substantial justice. Kinds of employment. Regular. Article 295, Regular and Casual Employment. The provisions of written agreement to the contrary, notwithstanding and regardless of the oral agreement of the parties, an employment shall be deemed to be regular where the employee has been engaged to perform activities which are usually necessary or desirable in the usual business or trade of the employer, except where the employment has been fixed for a specific project or undertaking, the completion or termination of which has been determined at the time of the engagement of the employee, or where the work or service to be performed is seasonal in nature and the employment is for the duration of the season. An employment shall be deemed to be casual if it is not covered by the preceding paragraph, provided that any employee who has rendered at least 1 year of service, whether such service is continuous or broken, shall be considered a regular employee with respect to the activity in which he is employed, and his employment shall continue while such activity exists. Article 296, Probationary Employment. An employee who is allowed to work after a probationary period shall be considered a regular employee. Regular employment is not synonymous with permanent employment because there is no such thing as a permanent employment. Any employee may be terminated for just cause. A regular employee is one who is engaged to perform activities which are necessary and desirable in the usual business or trade of the employer, as against those which are undertaken for a specific project or are seasonal. Article 295 provides two kinds of regular employees. One, those engaged to perform activities which are necessary or desirable in the usual business or trade of the employer, and two, casual employees who have rendered at least 1 year of service, whether continuous or broken, with respect to the activity in which they are employed. Romaris versus NLRC, decided 1998. Primary standard to determine regular employment, reasonable connection rule. The primary standard to determine a regular employment is the reasonable connection between the particular activity performed by the employee in relation to the business or trade of the employer. The test is whether the former is usually necessary or desirable in the usual business or trade of the employer. if the employee has been performing the job for at least 1 year, even if the performance is not continuous or merely intermittent. The law deems the repeated and continuing need for its performance as sufficient evidence of the necessity, if not indispensability, of that activity to the business of the employer. Hence, the employment is also considered regular, but only with respect to such activity and while such activity exists. Forever Returns Trading Corporation versus Molina, decided 2013. When applicable, Article 295 is not the yardstick for determining the existence of an employment relationship because it merely distinguishes between two kinds of employees, that is, regular employees and casual employees, for purposes of determining the right of an employee to certain benefits, to join or form a union, or to security of tenure. It does not apply where the existence of an employment relationship is in dispute. Atok Big Wedge Company Incorporated versus Gison, decided 2011. Hiring for an extended period, where the employment of proper project employees is extended long after the supposed project has been finished, the employees are removed from the scope of project employees and considered regular employees. Odeon Electric Company Incorporated versus NLRC, decided 1999. While length of time may not be a controlling test for project employment, it can be a strong factor in determining whether the employee was hired for a specific undertaking, or in fact tasked to perform functions which are vital, necessary, and indispensable to the usual business or trade of the employer. Tomaslaw Construction versus NLRC, decided 1997. Repeated renewal of contract. While the court has recognized the validity of contractual stipulations as to the duration of employment, this cannot apply where the contract-to-contract agreement was but an artifice to prevent her from acquiring security of tenure and to frustrate constitutional decrees. Beta Electric Corporation versus NLRC, decided 1990. Length of time involved. Length of time is not controlling, merely serves as a badge of regular employment. Maraginot versus NLRC, decided 1998. Casual. Article 295, regular and casual employment. An employment shall be deemed to be casual if it is not covered by the preceding paragraph, provided that any employee who has rendered at least 1 year of service, whether such service is continuous or broken, shall be considered a regular employee with respect to the activity in which he is employed, and his employment shall continue while such activity exists. Section 5B, Rule 1, Book 6, Implementing Rules and Regulations of Casual Employment. There is casual employment where an employee is engaged to perform a job, work, or service which is merely incidental to the business of the employer, and such job, work, or service is for a definite period made known to the employee at the time of engagement, provided that any employee who has rendered at least 1 year of service, whether such service is continuous or not, shall be considered a regular employee with respect to the activity in which he is employed, and his employment shall continue while such activity exists. A casual employee is engaged to perform a job, work, or service which is merely incidental to the business of the employer, and such job, work, or service is for a definite period made known to the employee at the time of engagement. Someone who is not a regular, project, or seasonal employee. Requirements to become regular employee. 1. 1 year service, continuous or broken with respect to activity employed. 2. Employment shall continue while such activity exists. Nature of work. What determines regularity or casualness is not the employment contract, written or otherwise, but the nature of the job. If the job is usually necessary or desirable to the main business of the employer, then employment is regular. A.M. Oreta and Company Incorporated versus NLRC, decided 1989. 1-year service, as held in Philippine Bank of Communications versus NLRC, a temporary or casual employee under Article 281 of the Labor Code becomes regular after service of 1 year unless he has been contracted for a specific project. Tabas versus California Marketing Company Incorporated, decided 1989. If the employee has been performing the job for at least 1 year, even if the performance is not continuous or merely intermittent, the law deems the repeated and continuing need for its performance as sufficient evidence of the necessity, if not indispensability, of that activity to the business. Integrated Contractor and Plumbing Works versus NLRC, decided 2005. Probationary, Article 296. Probationary employment. Probationary employment shall not exceed 6 months from the date the employee started working unless it is covered by an apprenticeship agreement stipulating a longer period. The services of an employee who has been engaged on a probationary basis may be terminated for a just cause or when he fails to qualify as a regular employee in accordance with reasonable standards made known by the employer to the employee at the time of his engagement. An employee who is allowed to work after a probationary period shall be considered a regular employee. Section 6D, Rule 1, Book 6, Implementing Rules and Regulations, Probationary Employment. In all cases of probationary employment, the employer shall make known to the employee the standards under which he will qualify as a regular employee at the time of his engagement. Where no standards are made known to the employee at the time of engagement, he shall be deemed a regular employee. Definition. A probationary employee is one who is made to go on a trial period by an employer, during which the employer determines whether or not he is qualified for permanent employment, based on reasonable standards made known to him at the time of engagement. Robinson's Galleria et al. Versus Ranches, decided 2011. Duration, according to Article 296. General rule, probationary employment shall not exceed 6 months from the date the employee started working. Exceptions. When it is covered by an apprenticeship agreement stipulating a longer period, Article 296. 2. When the parties to the employment contract agree otherwise, such as when established by company policy or required by the nature of the work performed by the employee. San Miguel Corporation versus Del Rosario, decided 2005, citing Buiser versus Leogardo, decided 1984, or 3. When it involves the 3-year probationary period of teachers, Mercado versus Ama Computer College, decided 2010. 4. When it involves an act of liberality on the part of his employer, affording him a second chance to make good after having initially failed to prove his worth as an employee. Mariwasa versus Leogardo, decided 1989. Purposes. 1. Observance period. For employer to determine if employee is qualified and for employee to demonstrate to the ER his skills. 2. Restrictive. As long as determination was made before the expiration of the 6-month probationary period, the employer has a right to sever the employer-employee relationship. Indeed, the employer has a right or is at liberty to choose as to who will be hired and who will be declined. It is within the exercise of this right to select his employees that the employer may set or fix a probationary period within which the latter may test and observe the conduct of the former before hiring him permanently. Grand Motor Parts Corporation versus Mole, decided 1984. Standards to qualify as a regular employee. Requirements. 1. The employer must communicate the regularization standards to the probationary employee and 2. The employer must make such communication at the time of the probationary employee's engagement. If the employer fails to comply with either, the employee is deemed as a regular and not a probationary employee. The employer has the burden of proof to show that they have informed the probationary employee of the standards to be applied to his or her work, that those standards have been applied to him or her, and that he or she fell short of such standard. An employer is deemed to have made known the standards that would qualify a probationary employee to be a regular employee when it has exerted reasonable efforts to apprise the employee of what is expected to do or accomplish during the trial period of probation. This goes without saying that the employee is sufficiently made aware of his probationary status as well as the length of time of the probation. The exception to the foregoing is when the job is self-descriptive in nature. For instance, in the case of maids, cooks, drivers, or messengers. Abbott Laboratories Philippines versus Alcaraz, decided 2013. In all cases of probationary employment, the employer shall make known to the employee the standards under which he will qualify as a regular employee at the time of his engagement. When no standards are made known to the employee at that time, he shall be deemed a regular employee. Conversely, an employer is deemed to substantially comply with the rule on notification of standards if he apprises the employee that he will be subjected to a performance evaluation on a particular date after his hiring. Alcira versus NLRC, decided 2004. Regular status after probation. When the bank renewed the contract after the lapse of the 6-month probationary period, the employees thereby became regular employees. No employer is allowed to determine indefinitely the fitness of its employees. Bernardo versus NLRC. Double probation. There is no basis for subjecting an employee to a new probationary or temporary employment where he had already become a regular employee when he was absorbed by a sister company. A Prime Security Services Incorporated versus NLRC, decided 2000. Absorbed employees not probationary. The private respondents could not be considered probationary employees because they were already well trained in their respective functions. As stressed by the Solicitor General, while private respondents were still with the CCAS, they were already clerks. Respondent Gelig has been a clerk for CCAS for more than 10 years, while Respondent Quijano had slightly less than 10 years of service. They were, therefore, not novices in their jobs but experienced workers. Cebu Stevedoring Company Incorporated versus Regional Director, decided 1988. Private school teachers. Questions respecting a private school teacher's entitlement to security of tenure are governed by the Manual of Regulations for Private Schools and not the Labor Code. Aklan College versus Guarino, decided 2007. The legal requisites, therefore, for acquisition by a teacher of permanent employment or security of tenure are 1. A full-time teacher, 2. Must have rendered 3 consecutive years of service, and 3. Service must have been satisfactory. La Salette of Santiago versus NLRC, decided 1991. Mere completion of the 3-year probation, even with above average performance, does not guarantee that the employee will automatically acquire a permanent employment status. The probationer can only qualify upon fulfillment of the reasonable standards set for permanent employees as a member of the teaching personnel. Herrera Manawis versus St. Scholastica's College, decided 2013. These standards should be made known to the teachers on probationary status at the start of their probationary period, or at the very least under the circumstances of the present case, at the start of the semester or the trimester during which the probationary standards are to be applied. Of critical importance in invoking a failure to meet the probationary standards is that the school should show, as a matter of due process, how these standards have been applied. Colegio del Santísimo Rosario versus Rojo, decided 2013. Termination. A probationary employee enjoys only a temporary employment status. This means that he is terminable at any time, permanent employment not having been attained in the meantime. The employer could well decide he no longer needed the probationary employee services, or his performance fell short of expectations, etc. As long as the termination was made before the termination of the 6-month probationary period, the employer was well within his rights to sever the employer-employee relationship. A contrary interpretation would defect the clear meaning of the term probationary. De la Cruz Jr. versus NLRC, decided 2003. A probationary employee can only be terminated for 1. Just causes, 2. Authorized causes, or 3. Failure to qualify as a regular employee in accordance with reasonable standards made known by the employer to the employee at the time of engagement. Robinson's Galleria et al. Versus Ranches, decided 2011. The probationary employee is entitled to substantial and procedural due process before termination. Limits to termination. It must be exercised in accordance with the specific requirements of the contract. 2. If a particular time is prescribed, the termination must be within such time and if formal notice is required, then that form must be used. 3. The employer's dissatisfaction must be real and in good faith, not feigned so as to circumvent the contract or the law. 4. There must be no lawful discrimination in the dismissal. Manila Hotel Corporation versus NLRC, decided 1986. In order to invoke failure to meet the probationary standards as a justification for dismissal, the employer must show how these standards have been applied to the subject employee. Univac Development Incorporated versus Soriano, decided 2013. Repeated renewal of contract. When an employer renews a contract of employment after the lapse of the 6-month probationary period, the employee thereby becomes a regular employee. No employer is allowed to determine indefinitely the fitness of its employees. Malikdem versus Marulas Industrial Corporation, decided 2014. Project. Article 295, Regular and Casual Employment. The provisions of written agreement to the contrary, notwithstanding and regardless of the oral agreement of the parties, an employment shall be deemed to be regular where the employee has been engaged to perform activities which are usefully necessary or desirable in the usual business or trade of the employer, except where the employment has been fixed for a specific project or undertaking, the completion or termination of which has been determined at the time of the engagement of the employee, or where the work or service to be performed is seasonal in nature, and the employment is for the duration of the season. A project employee is one who is hired for carrying out a separate job distinct from the other undertakings of the company, the scope and duration of which has been determined and made known to the employees at the time of employment. Hanjin Heavy Industries and Construction Company versus Ibanez, decided 2008. Rationale for a project employment. If a project has already been completed, it would be unjust to require the employer to maintain them in the payroll while they are doing absolutely nothing except waiting until another project is begun, if at all. In effect, these standby workers would be enjoying the status of privileged retainers, collecting payment for work not done to be dispersed by the employer from profits not earned. De Ocampo versus NLRC, decided 1990. Two kinds of project employee. One, for a particular job or undertaking that is within the regular or usual business of the employer company, but which is distinct and separate and identifiable as such from the other undertakings of the company, that is construction. For a particular job or undertaking that is not within the regular business of the corporation. Such a job or undertaking must also be identifiably separate and distinct from the ordinary or regular business operations of the employer. Villa versus NLRC, decided 1988. Indicators of project employment. 1. The duration of the specific identified undertaking for which the worker is engaged is reasonably determinable. 2. Such duration, as well as the specific work or service to be performed, is defined in an employment. 3. Agreement and is made clear to the employee at the time of the hiring. 4. The work or service to be performed by the employee is in connection with the particular project undertaking for which he is engaged. 5. The employee, while not employed and awaiting engagement, is free to offer his services to any other employer. 6. The termination of his employment in the particular project or undertaking is reported to the Dole Regional Office, having jurisdiction over the workplace following the date of his separation from work, using the prescribed form on employees' terminations or dismissals or suspensions. 7. An undertaking in the employment contract by the employer to pay completion bonus to the project employee as practiced by most construction companies. Department Order Number 19, Section 2.2, also mentioned in Samson versus NLRC, decided 1996. Test of project employment. The litmus test in determining the existence of project employment is whether or not the employment has been fixed for a specific project or undertaking, the completion or termination of which has been determined at the time of the engagement of the employee. DM Konsunji versus NLRC, decided 2000. Evidently, although the employment contract did not state a particular date, it did specify that the termination of the parties' employment relationship was to be on a day certain, the day when the place of or the phase of work, termed lifting and hauling of materials, for the World Finance Plaza project would be completed. Thus, respondent cannot be considered to have been a regular employee. He was a project employee. Filipinas Prefabricated Building Systems Incorporated versus Puente, decided 2005. Repeated hiring, length of service not determinant of regularity of employee. The repeated and successive rehiring of project employees do not qualify them as regular employees, as length of service is not the controlling determinant of the employment tenure of a project employee, but whether the employment has been fixed for a specific project or undertaking. Its completion has been determined at the time of the engagement of the employee. Leyte Geothermal Power Progressive Employees Union versus Philippine National Oil Company, decided 2011. The simple fact that the employment as project employees has gone beyond 1 year does not detract from or legally dissolve their status as project employees. The second paragraph of Article 280 of the Labor Code, providing that an employee who has served at least 1 year shall be considered a regular employee, relates to casual employees, not to project employees. Raycor Air Control Systems versus NLRC, decided 1996. Generally, length of service provides a fair yardstick for determining when an employee initially hired on a temporary basis becomes a permanent one, entitled to the security and benefits of regularization. But this standard will not be fair if applied to the construction industry, simply because construction firms cannot guarantee work and funding for its payrolls beyond the life of each project. And getting projects is not a matter of course. William Uy Construction Corporation versus Trinidad, decided 2010. Work pool employee. Members of a work pool from which a construction company draws its project employees, if considered employees of the construction company, while in the work pool, are non-project employees or employees for an indefinite period. If they are employed in a particular project, the completion of the project or any phase thereof will not mean severance of the employer-employee relationship. As decided in Aguilar Corporation versus NLRC, decided 1997. Project employees may or may not be members of a work pool. That is, the employer may or may not have formed a work pool at all. And in turn, members of a work pool could be either project employees or regular employees. Raycor Air Control Systems versus NLRC, decided 1996. A work pool may exist although the workers in the pool do not receive salaries and are free to seek other employment during temporary breaks in the business, provided that the worker shall be available when called to report for a project. Although primarily applicable to regular seasonal workers, this setup can likewise be applied to project workers insofar as the effect of temporary cessation of work is concerned. Maraginot versus NLRC, 1998. When a project employee or a member of a work pool requires the status of regular employment, the following requisites must concur. 1. There is continuous rehiring of project employees even after cessation of project. 2. The tasks performed by the alleged project employees are vital, necessary, and indispensable to the usual business or trade of the employer. Imbuido versus NLRC, decided 2000. Maraginot versus NLRC, decided 1998. Note, the length of time which the employees are continually rehired is not in itself controlling, but merely serves as a badge of regular employment. As decided in Leyte Geothermal Power Progressive Employees Union versus Philippine National Oil Company, decided 2011. Termination. Rule on reportorial requirement. A report of termination to the nearest public employment office every time their employment was terminated due to completion of each construction project. Failure of the employer to file termination reports after each project completion proves that the employees are not project employees. Pasos versus Philippine National Construction Corporation, decided 2013. Seasonal. Article 295, first paragraph. Where the work or service to be performed is seasonal in nature and the employment is for the duration of the season. Seasonal employees are those whose work or services are to be performed are seasonal in nature. Employment is for the duration of the season. There is no continuing need for the worker. Regular seasonal employees after one season. Seasonal workers who are constantly rehired and only temporarily laid off during off-season are not separated from service in said period, but are merely considered on leave until work resumes. They are considered regular and permanent employees. The nature of their relationship is such that during off-season they are temporarily laid off, but during summer season they are re-employed, or when their services may be needed, they are not strictly speaking separated from the service, but are merely considered as on leave of absence without pay until they are re-employed. Philippine Tobacco, Flue Curing and Redrying Corporation versus NLRC, decided 1998. Illustrative cases. For respondents to be considered seasonal employees, it is not enough that they perform work or services that are seasonal in nature. They must have been employed only for the duration of one season. The evidence proves the existence of the first, but not of the second condition. The fact that respondents repeatedly worked as sugarcane workers for petitioners for several years is not denied by the latter. Evidently, petitioners employed respondents for more than one season. Therefore, the general rule of regular employment is applicable. Hacienda Fatima versus National Federation of Sugarcane Workers, decided 2003. Citing Hacienda Fatima, the court in Hacienda Vino versus Cuenca, decided 2005, ruled that while the records sufficiently show that the respondents' work in the hacienda was seasonal in nature, there was, however, no proof that they were hired for the duration of one season only. In fact, the payrolls submitted in evidence by the petitioners show that they availed the services of the respondents since 1991. Absent any proof to the contrary, the general rule of regular employment should, therefore, stand. It appears that the questioned employees were never separated from the service, continuous rehiring. Their status is that of regular seasonal employees who are called to work from time to time, mostly during summer season. The nature of their relationship with the hotel is such that during off season they are temporarily laid off, but during summer season they are re-employed, or when their services may be needed. They are not strictly speaking separated from the services, but are merely considered as on leave of absence without pay until they are re-employed. Their employment relationship is never severed, but only suspended. As such, these employees can be considered as in the regular employment of the hotel. Manila Hotel versus CIR, decided 1963. Exception. Although respondent constantly availed herself of the petitioner's services, from year to year, it was clear from the facts therein that they were not in her regular employ. Petitioners therein performed different phases of agricultural work in a given year. However, during that period, they were free to work for other farm owners, and in fact they did. In other words, they worked for respondent, but were nevertheless free to contract their services with other farm owners. The court was thus emphatic when it ruled that petitioners were mere project employees who could be hired by other farm owners. Mercado Senior versus NLRC, decided 1991. Fixed term. Article 295 has no application to instances where 1. A fixed period of employment was agreed upon knowingly and voluntarily by the parties without any force, duress, or improper pressure being brought up to bear upon the employee and absent any other circumstances vitiating his consent, or 2. Where it satisfactorily appears that the employer and employee dealt with each other on more or less equal terms with no moral dominance whatever being exercised by the former over the latter. Brent School versus Zamora, decided in 1990. Note, the employee in this case was a college graduate. The Brent doctrine is applicable only in a few special cases wherein the employer and employee are on more or less equal footing in entering into a contract. The reason for this is evident. When a prospective employee, on account of special skills or market forces, is in a position to make demands upon the prospective employer, such prospective employee needs less protection than the ordinary worker. GMA Network versus Pabriga, decided 2013. The level of protection to labor must be determined on the basis of the nature of the work, qualifications of the employee, and other relevant circumstances. For example, a prospective employee with a bachelor's degree cannot be said to be on equal footing with a grocery bagger with a high school diploma. Fuji Television Network Incorporated versus Espiritu, decided 2014. Determining factor. The test in this kind of contract is not the necessity and desirability of the employer's activities, but the day certain agreed upon by the parties for the commencement and termination of the employment relationship. Brent School versus Zamora, decided 1990. GMA Network versus Pabriga, decided 2013. Fuji Television Network Incorporated versus Espiritu, decided 2014. A regular fixed-term employee. When an employee's contract has been continuously extended or renewed to the same position, with the same duties and remained in the employ without any interruption, then such employee is a regular employee. The employee's contract indicating a fixed term did not automatically mean that he or she could never be a regular employee. An employee can be a regular employee with a fixed-term contract. The law does not preclude the possibility that a regular employee may opt to have a fixed-term contract for valid reasons. This was recognized in Brent for as long as it was the employee who requested or bargained that the contract have a definite date of termination, or that the fixed-term contract be freely entered into by the employer and the employee, then the validity of the fixed-term contract will be upheld. Fuji Television Network Incorporated versus Espiritu, decided 2014. Project employment and fixed-term employment distinguished. A project employee is assigned to carry out a specific project or undertaking, the duration and scope of which were specified at the time the employee is engaged for the project. The duration of a fixed-term employment agreed upon by the parties may be any day certain, which is understood to be that which must necessarily come, although it may not be known when. The decisive determinant in fixed-term employment is not the activity that the employee is called upon to perform, but the day certain agreed upon by the parties for the commencement and termination of the employment relationship. GMA Network versus Pabriga, decided 2013. Independent contractors distinguished from fixed-term employees. No employer-employee relationship exists between independent contractors and their principals. Their contracts are governed by the Civil Code provisions on contracts and other applicable laws. Employees under fixed-term contracts cannot be independent contractors. Those engaged in legitimate job contracting or those who have unique skills and talents, because in fixed-term contracts, an employer-employee relationship exists. Fuji's argument that Arlene was an independent contractor under a fixed-term contract is contradictory. Employees under fixed-term contracts cannot be independent contractors because in fixed-term contracts, an employer-employee relationship exists. Fuji Television Network Incorporated versus Espiritu.